Hi, I am Mahendri Naidu, a private client solicitor with Moore Kingston Smith. Much of my time is spent advising clients on their wills and helping them plan for the future. Today, I'd like to talk to you about the importance of regularly reviewing and amending your will to ensure that it suits your current wishes and circumstances. When should you review your will? Well, essentially, you should review your will every 3 to 5 years or whenever there's a life-changing event. Some examples of life-changing events are marriage, birth of a child, divorce or separation, or death of a loved one. Today I'd like to focus on 3 life-changing events, and that's marriage, divorce, and bereavement. Looking at the statistics for divorces and marriages and civil partnerships, we find that despite the large number of marriages and divorces, there is often some confusion as to what happens to an existing will when the will maker marries, divorces, or separates. Looking at marriage, marriage would automatically revoke a pre-existing will. And unless a new will is put in place, you are likely to die intestate, which would mean that assets will not pass to those who had intended and will pass in terms of the laws of intestacy. For example, your estate may be split between your surviving spouse and children. So what should you be doing before your marriage? Well, you can make a will in contemplation of your marriage. A special clause is inserted in your will confirming that the will not be revoked on your marriage to your intended and will stand in the event that the marriage does not occur. Also very important when looking at your will pre-marriage is to consider whether you have any foreign wills, because the laws relating to marriage and wills could vary from country to country. For example, in South Africa, a marriage does not automatically revoke a will, and your will stand regardless of the date of your marriage. Divorce, on the other hand, does not automatically revoke a will. What happens is that divorce will change the way your former spouse is treated in law. So once the divorce absolute is granted, for the purposes of your will, any provisions made for your former spouse will fail, and your former spouse is seen to have predeceased you as such when it comes to the reading of the will. So for example, if your former spouse is still named as the beneficiary of the will, and the will was signed before the decree absolute was granted, on your death, any gift made to the former spouse would fail and will pass to a substitute beneficiary if you've made provision for that, or to the residue of your estate, and then in terms of the provisions made for the residue. Now, often we see wills where everything is left to a spouse with no substitute beneficiaries. In these instances, if the testator were to divorce and not put a new will in place, that will would effectively fail in the sense that there would be no beneficiary of the will and would thus have to pass in terms of the laws of intestacy. So what should you be doing if you're about to get divorced or have been divorced? Well, you should consider making a new will. If it's pre-divorce, so pre the decree absolute being granted, remember your spouse can make a claim against your estate. So you should ensure that some provision is made for your spouse, maybe in terms of the divorce settlement that you are likely to agree, or provide reasons for excluding your estranged spouse. Once the divorce is finalized, ensure your will is amended to reflect your current wishes against any intestacy, or it could be that you would still like your former spouse to benefit. So you would need to sign a new will reinstating their benefit in your estate. Bereavement. What happens if a beneficiary dies before you? A specific gift will lapse and pass to a substitute beneficiary, you have made provision. So, for example, if you give £5,000 to A and failing A to B, if A predeceases you, on your death, that gift will automatically pass to B. However, if you made no provision, so for example, you gave £5,000 to A, but made no provision for this to pass to someone else if A predeceases you, that gift will pass to the residue of your estate and pass in terms of the provisions you've made for the residue. It's important when looking at the residue to ensure that you've made substitute gifts for a residue. So if you have not done this, then once again, your estate is likely to pass in the terms of intestacy. We find that clients tend to choose charities, and this is something that's really advisable, as the ultimate beneficiary of your estate. So if the worst case scenario happens, your beneficiaries have died, the substitutes have died, your estate would pass to the ultimate beneficiary being the charity, therefore safeguarding it having to go in terms of the laws of intestacy. And in some instances where you have no distant relatives to inherit, it can pass to the Crown. So by having a charity in place, you ensure that there is a beneficiary of your choosing that will ultimately inherit. An important section to look at and consider is Section 33 of the Wills Act. And this relates to any gifts you may leave to a child or remoter issue, so grandchildren or great-grandchildren. Unless this section is specifically excluded in your will, the gift will automatically pass to the grandchildren or great-grandchildren. What happens if a beneficiary dies after you? The beneficiary will be entitled to the gift on your death. The gift would have to be paid to the beneficiary's estate and will pass in terms of the beneficiary's will, or if there's no will, under the rules of intestacy. You could safeguard against this by making the gift contingent on the beneficiary surviving you for a period of time. How long is that period of time? Often the choices have been between 30 days and 90 days. And the reason for this is that any longer can delay the estate administration. So for example, if you choose a year as a contingency period, your executors will have to keep your estate open for a year and can only make a distribution once that year has elapsed, which might not be feasible from a tax point of view or an administrative point of view. So therefore you need to consider carefully the time period that you'd like your beneficiaries to survive with you. So this is just a brief overview of the three aspects we spoke about. And it's definitely important, as I've said before, to regularly review your will to ensure that they suit your current circumstances and wishes, and are amended to reflect any changes you'd like made.